All right, thank you, Madam Clerk. You call the next case, please.
Rico Eugene Mallard versus State of Tennessee.
May it please the court. Good morning, Your Honors. I'm Dawn Diener, and I'm here this morning on behalf of the petitioner appellant, Rico Mallard. I do want to note two things. First, I'd like to reserve 3 minutes for rebuttal, if I can, please. And secondly, I am here with a very late filed notice of appearance. The brief in this matter was written by my colleague, Chase Cunningham, who suffered a death in his family a week ago. And rather than continue it, we wanted to move forward, and I appreciate the court allowing me to come in and do the oral argument.
We appreciate your proceeding with it, and thank you.
Thank you. The issue this court is asked to address this morning is whether the trial court erred by summarily dismissing Mr. Mallard's post-conviction petition as untimely. The answer to that question is yes. His petition stated a colorable claim that was rooted in the newly recognized and retroactive right announced by the Tennessee Supreme Court in State v. Tyshawn Booker. Because of that, he was entitled to an evidentiary hearing in the trial court to introduce his evidence and proof in support of his claims and to make his arguments, a full argument to that court.
What was the issue in Booker that was retroactive that applied to his case?
So the issue in Booker is that, first of all, the primary holding is that youth matters in sentencing in Tennessee
First-degree murder case.
For juvenile homicide offenders.
And my understanding is Mr. Mallard is going to be getting a parole hearing?
Mr. Mallard will be getting a parole hearing, a custodial parole hearing on his life sentence, yes.
Okay.
He will.
Okay.
Even with that, however, even if he were to parole, he has a consecutive 22-year sentence on top of that,
Okay.
which effectively for him will mean incarceration for at least 51 years.
Okay.
And
So
that
how does Booker apply to that?
Well, Booker, number one, said that youth matters, and that in sentencing juvenile homicide offenders who are facing the most serious punishments this state can impose, have a right to have youth and the mitigating circumstances of youth considered in their punishment.
Wasn't that considered in the sentencing on his, specially aggravated robbery?
It was not, and that is what Mr. Mallard's petition alleged.
Why do you say it was not?
Well,
He had a sentencing hearing, obviously, and the court had to, the murder case obviously was automatic life sentence, so there was
Yes.
no consideration, which is what Booker was concerned about.
yes,
Now, his remaining charge, there was a sentencing hearing.
There was a sentencing hearing.
And the court could consider all those factors, enhancements and mitigation, including youthfulness, is one of the considerations in mitigation.
in
So-
setting the length of sentence, yes.
Okay.
Yes.
Which what the court then came up with 22 years consecutive.
The court sentenced him to 22 years consecutive, but there is no evidence before the court that he considered youth in doing that.
But at the time that he was sentenced, he had a right to appeal the sentence and argue that the court imposed the sentence improperly.
He did have the right to file an appeal of his sentence. However, he did not have the right that Booker acknowledged and recognized newly, which was that his youth matters and that youth must be considered.
And Booker was dealing with automatic life sentences for first-degree murder.
That is the outcome of that case because that was the factual scenario that presented in Mr. Booker's case. Mr. Booker, too, was convicted of an especially aggravated robbery and had a sentencing hearing, and the trial court in that case imposed a concurrent sentence.
But Booker, what Booker was concerned about was the life sentence, automatic life sentence for a youthful offender, for a juvenile offender, getting 51 years when there has been no consideration at all about his youth. That was the consideration in Booker.
Yes, I would agree with that, with Your Honor on that.
Okay, and in this particular case, Mr. Mallard, he didn't appeal, if I remember correctly, this sentence. Is that correct?
Mr. Mallard's lawyers essentially abandoned him at 19.
But my question, 20 years ago, he did not appeal this issue about the consecutive sentencing in a sentence.
20 years ago, he had no motion for new trial filed. He had no appeal filed. He had no motion of his counsel to withdraw and to appoint other counsel filed. He had nothing. And so, no, he did not appeal. But the point that we are raising here is that what Booker recognized was a new constitutional right that did not exist for Mr. Mallard at that time. And that right is framed in Booker in the context of the automatic life sentence. But it's not the automatic nature that Booker was addressing specifically. The underpinning of the automatic nature of that life sentence is that there is no opportunity, number one, for youth to be considered. And there's no requirement for youth to be considered. And Tennessee's consecutive sentencing scheme suffers from the same problems as the automatic life sentence when it is imposed upon juvenile homicide offenders convicted and facing the most serious punishments. There is nothing in Tennessee's consecutive sentencing scheme that requires trial courts to consider youth. Yes, trial courts have discretion to consider youth, but that's not what the holding in Booker says is minimally acceptable. What Booker says is that trial courts are required to consider youth. And there's nothing in the record that indicates, and what Mr. Mallard's post-conviction petition alleged was that the trial court did not consider his youth. And his petition alleged that, and he was entitled to an evidentiary hearing in order to have a transcript prepared of his sentencing hearing.
Okay, well, let me go back to what we were talking about before, though. Is you're saying this is a newly arising right. However, at the time he was sentenced, he had a right to appeal his sentence and argue that it was improper amount of time, it was improperly consecutive. These were rights he had at the time of his conviction.
Yes.
So why isn't this waived now? Because he could have raised it before a court of competent jurisdiction at a much earlier time than 20 years after the fact under post-conviction. Booker really doesn't create an avenue for him to attack this sentence. It was appealable at the time.
I disagree that Booker does not create an avenue because Booker recognizes a different right and a new right that did not exist in 1999.
And again, youth was something that is one of the statutory mitigators the court's supposed to consider.
That a court could consider and has the discretion to consider, but is
again,
not required.
But you're saying that the court didn't consider it, and there's no evidence the court didn't consider it because it wasn't appealed.
Well, what I am saying is that Booker does more than say the court can consider it. What Booker says is that a court is required to consider it when imposing the state's harshest punishments on juvenile homicide offenders. Mr. Mallard was a juvenile homicide offender. There's no doubt about that. And the court imposed a consecutive 22-year sentence without any consideration of his youth. And yes, we are saying that the record does not contain any information about that and that the trial court didn't do that. The reality here, though, is that Mr. Mallard wasn't given the opportunity at an evidentiary hearing at the trial court on his post-conviction petition to create that record. Had the trial court granted a colorable claim order, he could have proceeded with an evidentiary hearing. Mr. Mallard could have had a transcript of his sentencing hearing prepared, and that could have been introduced at the hearing on his post-conviction petition. What we do know from the record, the sparse record that exists here, is the Rule 12 report that the trial court filled out is completely blank in the portions where it's asked about youth and mitigating circumstances related to youth. There's no mention that the trial court considered anything related to Mr. Mallard's youth. And what I'm fundamentally saying about Booker, and what Booker did, was it created a right to have his youth considered. And that is something different than a trial court having discretion to consider it and simply choosing to give it no weight.
It appears to me, and I think Judge Campbell has hit on this too, that one of the key phrases in Booker has to do with, in a first-degree murder case, juvenile or otherwise, the sentence, if convicted, is automatic. And what is the automatic sentence for especially aggravated robbery? There isn't one. You have to have a sentencing hearing and go through it. and the judge can consider whatever factors that are brought before him. And obviously, it would be, I assume, obvious the age of this defendant. But how does Booker apply? And I think, let me read this. Juvenile first-degree murder cases, and only in these cases, a sentence is automatically imposed without considering age, the nature of the crime, or any other factors. Isn't that the only place where that happens? Maybe there's some mandatory sentencing too, but typically that's where it's automatic. You don't even have to have a sentencing hearing if they're not seeking life without or death.
Yes, I think that is the only place where an automatic sentence is imposed. However, having an automatic sentence imposed is not the only way to violate the Eighth Amendment. It's not the only way to impose a cruel and unusual punishment on a juvenile homicide offender. Mr. Mallard walked away from his sentencing hearing with a 70-plus year sentence without any consideration of his youth, both related to the automatic homicide sentence, the murder sentence, but no consideration of his youth or mitigating circumstances in the imposition of a consecutive 22-year sentence.
And Booker has provided him a parole type hearing, or whatever they call it, probation hearing, whichever it is in first-degree murder. Is that correct?
Yes, he will get a parole hearing on his murder case, and even if he paroles, he will have to serve a minimum of another 19 years.
And if he wasn't convicted of especially aggravated robbery, he wouldn't have to. Is that correct? If he'd have just been convicted of first-degree murder under Booker, he would have gotten a parole hearing because of his age.
Yes, if he had only been convicted of first-degray murder, that
And
was
that's
it.
because it's an automatic life sentence.
Yes, that is. And again, the point that I'm trying to make here that I think is really important is that an automatic life sentence is not the only way to violate the Constitution and impose a cruel and unusual punishment that failed to consider Mr. Mallard's youth. And that is what the Booker holds, is that in Tennessee, youth, juvenile homicide offenders, are entitled to have a sentencing court consider their youth in determining what their sentence should be.
Whether it should be life or something else.
Life or life plus 22 years, adding a consecutive sentence. And so there's nothing in Tennessee's consecutive sentencing scheme, there wasn't in 1999 and there is not now, that requires a court to consider youth and the mitigating circumstances of youth before imposing a consecutive sentence. And that's the crux of the issue, that the consecutive sentencing scheme violates the Constitution, the Eighth Amendment, and permits cruel and unusual punishment in the same way that the automatic life sentence does, because there is not a requirement for sentencing judges to consider that. It is discretionary, yes, but Booker demands more. Booker says more. Mr. Mallard was entitled to more than just discretion of the court to consider that.
But in Booker itself, they talk about the fact that he was convicted of another offense. He was convicted
Yes.
of aggravated robbery, especially aggravated robbery. Now, in this particular, in Booker, it was concurrent, but the court contrasted the fact that he got a sentencing hearing for the especially aggravated robbery, and the court could consider all these factors that they couldn't consider when he got an automatic life sentence. So they distinguished the two. They said, because he doesn't get an individualized sentencing hearing, that's where it violates the Eighth Amendment, as opposed to the sentencing hearing he got for his other charge, especially aggravated robbery. So they recognized that there was a difference. They didn't say, well, it's unconstitutional because he wasn't required to consider his sentence. He said he got a separate sentencing hearing in that case as a contrasting what he got the automatic life sentence. And so they showed the distinction between the two, that he got a sentencing hearing. In this case, he got a sentencing hearing.
And they were able to do that in Booker because Mr. Booker had a robust sentencing hearing that was clear on the record. And so that was not a factual issue that arose there.
But isn't that an appellate issue for when he was originally convicted? That's what I'm saying. This didn't just arise under Booker. He had a right to an appeal back 20 years ago.
And 20 years ago, yes, he Had his lawyers not abandoned him, he could have filed an appeal. He could have said, I was improperly sentenced to consecutive sentencing because the trial court failed to make the appropriate factual findings to even give me consecutive sentencing. He didn't do that. That was a claim he could have raised then.
But isn't
What
it
he
waived
couldn't-
now? Isn't it waived now under the Post-Conviction Act?
It is not, Your Honor,
How is
because
it not?
he could not have raised the claim in 1999 that he had a constitutional right as a juvenile homicide offender to have the mitigating circumstances of his youth considered by the court a mandatory consideration.
Well, the court didn't find it was unconstitutional for Mr. Booker's sentencing, and it said there that the court could consider his youthfulness. It didn't say that there was a constitutional requirement that they consider his usefulness in this especially aggravated robbery conviction.
The court didn't have to go there in Booker. The court did not have to go there in Booker, number one, because the court imposed a concurrent sentence. So the issue of whether or not that concurrent sentence and the consecutive sentencing scheme was not before the court in Booker. Second, there was a robust sentencing hearing. And so they were able to point to the fact that with that robust sentencing hearing, see what happens. A court decides youthfulness does matter, and the court imposed a concurrent sentence. So those issues are not squarely before the court. What the court in Booker did find, though, which is what we're citing in this case for why Mr. Mallard is entitled at the very least to a post-conviction hearing, is it said that Tennessee's consecutive sentencing scheme, when imposed on juvenile homicide offenders, lacks the procedural protections necessary. And the procedural protections do not exist and did not exist around consecutive sentencing for juvenile homicide offenders because there is no requirement. The court is saying the holding of Booker, which relies on Miller and the whole history of the Supreme Court's decisions related to youthfulness, making a difference in sentencing under the Eighth Amendment, is that
Let me interrupt you here, because I got a quote from Booker. Thus, Tennessee's automatic life sentence, when imposed on juvenile offenders, lacks the necessary procedural protection to guard against disproportionate sentencing. It's talking specifically about the automatic life sentence.
Yes, and I would.
So you just said generally sentencing, I assume you were saying of this, especially aggravated robbery, lacked the necessary procedural protection.
Yes, I see my time. Can
We
I?
have a statute, understand, you have a statute that he can only impose consecutive sentences if he makes certain findings. And he has to go through, and so if he makes none of those findings, whether he's a juvenile or an adult, he has to give concurrent sentencing.
Right, and I would submit to the court, the trial court didn't make any of those findings, but because Mr. Mallard's lawyers abandoned him, he didn't raise that, and we're not raising that here. What we are raising here is a newly recognized right for that says that it's not the automatic nature of the automatic nature of the life sentence is problematic because it doesn't allow for consideration of youthfulness, and it doesn't require consideration of youthfulness.
And is it in this record that Mr. Mallard's lawyers abandoned him?
Well, what's in this record is that no motion for new trial was filed. Nothing was ever filed on behalf of Mr. Mallard.
I understand that. But the reason why that wasn't done is not in the record, is that correct?
And the reason there's no record is that the trial court denied the post-conviction petition summarily. And so Mr. Mallard wasn't even able to put his proof on. And that's why we're here today, simply asking the court to reverse and remand for an evidentiary hearing. Thank you.
Thank you, Counselor. Let's see, General Lundy.
Good morning again, Your Honors.
Morning.
May it please the court, counsel. My name is Will Lundy. I am an Assistant Attorney General, and I represent the state in this appeal. The state asked this court to affirm the post-conviction court's dismissal of the petition for post-conviction relief because Booker does not apply to the petitioner. I want to try to I think clarify some of the issues here. I think this case ultimately turns on the scope of Booker's actual holding, and I think what the petitioner is trying to do in his brief is bring in the reasoning that Booker relies on. And some of that reasoning is drawn from Miller and the other U.S. Supreme Court cases. And in so doing, what he's asking this court to do is expand the actual holding from Booker. But we're not here on direct appeal. If we were here on direct appeal, if this is all preserved below and we can argue these things, a defendant could, in another case, look at Booker and say, well, based on the logic of Booker, based on the logic of Miller, this should apply. We should get some kind of relief under the Eighth Amendment for a consecutive sentence. But we're not here on direct appeal. We're here on post-conviction relief. The defendant cannot overcome the statute of limitations, which is a jurisdictional bar to post-conviction relief, unless Booker directly applies to him. Now, in one sense, Booker does directly apply to this petitioner because he was convicted of first-degree murder and he was given an automatic life sentence. But as counsel pointed out, he will be getting the parole hearing and the remedy that Booker requires. And so that isn't the issue here. The question in this case is whether these broad principles from Booker should be applied in the context of the consecutive sentence that he received for his aggravated robbery conviction, and Booker simply does not extend that far such that it could be applied here on post-conviction relief. The Booker court said, we hold that an automatic life sentence when imposed on a juvenile homicide offender with no consideration of the juvenile's age or circumstances violates the prohibition against cruel and unusual punishment under the Eighth Amendment to the United States Constitution. That was the question that the court was called upon to answer, and that's how it answered it. The only question the court was answering was whether an automatic life sentence violated, when imposed on a juvenile first-degree murder defendant, violated the Eighth Amendment. In another place, the Booker court says, juvenile first-degree murder cases, and only in these cases, as Judge Holloway pointed out, a sentence is automatically imposed without considering age. And then the court said, thus Tennessee's automatic life sentence when imposed on juvenile offenders lacks the necessary procedural protection to guard against disproportionate sentencing. As the court has pointed out, Mr. Mallard received a sentencing hearing with regard to his aggravated robbery conviction. And something I think needs to be clarified is that, first of all, this is a completely different offense, and he's not being sentenced for murder. He's being sentenced for aggravated robbery. So what the court has to do is set the defendant's sentence, and in that process, as the court is well aware, we have aggravating factors, we have mitigating factors when looking at the length of the sentence. So that's part of the court's consideration. One of those mitigating factors is, of course, the defendant's youth. That's something that the court is allowed to consider as part of those procedural protections that are available when we're talking about anything other than the automatic life sentence for first-degree murder. So in setting that sentence, the court is going to consider these, the mitigating factor of youth with regard to length. And counsel is correct insofar as the consecutive sentencing statute doesn't mention youth. But it doesn't really make sense that the consecutive sentencing statute would. Because, as we're aware, the default in Tennessee is concurrent sentencing. So when we're looking at consecutive sentencing, essentially we're looking at enhancements, right? These are things that these are factors that the court has to consider, and you have to meet at least one of those factors in order to give a consecutive sentence. So if we're looking at something that would give us a sentence that goes above and beyond what is otherwise available, why would we have a provision for considering a mitigating factor in that statute? So again, the state's position is that Booker does not apply to the defendant's sentence because his aggravated robbery conviction is not a first-degree murder conviction, and the scope of the Booker holding is exceptionally narrow. It is the first-degree murder conviction and that automatic life sentence. If the court has no questions for me, I would ask this court to affirm the post-conviction court's dismissal of the petition. Thank you.
All right, thank you, General.
I actually think Mr. Lundy just made part of my point for me. The consecutive sentencing statute in Tennessee does not mention youth. Instead, the way it works is consecutive sentencing can only be imposed if the court makes a finding that one of the factors applies. And then the court has discretion to impose consecutive sentence or discretion to impose a concurrent sentence. Let's presume that the court found one of those factors. It's not in the record what factor he or she found, or the trial court found, but let's assume the court found one of those factors and therefore was empowered to impose a consecutive sentence. The court is able to do that, to impose that consecutive sentence that puts Mr. Mallard currently at a sentence longer than 51-year life sentence without any consideration of youthfulness, without any required consideration of youthfulness. And that is what Booker said was a problem with Tennessee's life sentence. It was the imposition of a 51-year sentence without any requirement of consideration of youth. And I'm quoting here from the state's brief, page 13. The Booker court held only that Tennessee's automatic life sentence with a minimum of 51 years when imposed on juveniles violates the Eighth Amendment. And it did so because the Supreme Court's cases hold that the Eighth Amendment requires the sentencer to take the mitigating qualities of youth into account to minimize the risk of a disproportionate sentence when juveniles are facing the possible imposition of a state's harshest punishments. The state says it's required. The consecutive sentencing statute does not provide any place where a consecutive sentence can be imposed with but requires consideration of youth. And that is the problem.
22 years the state's harshest punishment?
On top of 51?
No,
Yes.
just a question. Is 22 years the state's harshest punishment?
I would say when imposed on a juvenile homicide offender,
All right.
it is one of them.
I
And
understand.
Booker speaks to the state's harshest punishments, plural. So I would say it is, yes. Thank you.
It's my understanding, let me see if I think I understand both sides here, but just from a common sense standpoint, the language in Booker about juvenile offenders and why they need some special consideration, common sense says that's exactly right. You know, you've got some, in this case, a 17-year-old kid. I think we got another one on the docket later. There's a 14-year-old kid.
Yes.
I think what you would, I don't know if we can possibly get there procedurally on this case, but I think your point that I tend to agree with is anytime a juvenile is being tried and sentenced as an adult, it should pretty much be mandatory that the youthfulness and all these factors be considered by whoever's doing the sentencing. It's not mandatory except on the first degree murder that we've been talking about, but common sense says to me any juvenile who's being sentenced as an adult facing these kind of adult penalties, the person imposing the sentence, the court, should be required to consider the fact that whatever factors there might be in this particular juvenile's situation, just like what they're, and the language there in this case, this Tennessee Supreme Court case, what you're saying is that common sense says that should be applied to the other sentence, the ag robbery also. And you know, again, procedurally, we've got, well, it could have possibly been applied earlier, and we don't, but am I right about that? I mean, is that the basic thing that you would like, that people with common sense would like to see the law be here?
So I would say, my common sense, yes, that's what I want the law to be, and I would also say that's what the law is. That is what the Constitution says. That is
Right.
what Booker said the Constitution requires. And so I just want to make the distinction, it's not me wishing that this could happen, though I wish it could happen.
Right.
It
right.
is, what I would say is what Booker holds. It is what Booker holds, that this is required.
What you would have us do in this case is say, because Booker says what I've just expressed as common sense, that it should apply here.
Yes, and really just remand it to the trial court for an evidentiary hearing.
And I know your time is up, and let's narrow this real quickly, because this came up on a case a couple of terms ago, but procedurally here, this petition is filed, Judge Dozier heard
Correct.
it. And you're asking for a hearing, and we had something similar like this before, where we didn't think there was a ruling, we didn't think there'd been a hearing, and so we sent it back for a hearing, and the Supreme Court said there was a hearing. And so when you file this petition, and you may not know this, you probably do though, based on experience, but in this particular case, the petition is filed, and then the next thing that comes is an order from Judge Dozier, who's reviewed it without any lawyer input, just says, I've done this, it's dismissed, because the statute of limitation has run and Booker doesn't save it. Or is there a bunch of
No.
oral
So,
argument or anything like that?
there was not. The only minor correction I would make is the petition was filed with counsel. So he was represented by counsel when he filed the petition.
Right.
The court reviewed that petition and issued a summary order, a summary denial,
Okay.
without hearing.
Okay. That was my question. That's what we thought happened on this
Yes.
case a couple of months ago, but the Supreme Court disagreed. Apparently there was more to it than that, but all right,
That is
thank you
what
very
happened
much.
here. Thank you.
Call the next case, please.
State of Tennessee versus John Houston Polk III.
Good morning, Your Honors.
Morning.
May it please the court.